Hey, this is Lawsuit Legal, and today we want to talk to you about lawsuit financing, including the basics of pre-settlement funding and everything you should know before you sign. The first step with lawsuit financing is to determine what your case is worth. This is dependent on two aspects, liability and damages. Liability works by assigning a percentage of responsibility to the defendant on the injury and depends upon specifics of the case. Damages are financial losses a person sustains as a result of an injury, accident, or negligent action. The total for damages will depend upon the severity of the injury and the effects the injury has on the plaintiff's life. Damages can commonly include medical expenses, lost wages, emotional distress, mental anguish, and pain and suffering. According to a 2005 report by the Bureau of Justice Statistics, the median length for the resolution of a legal case varies per case type. An average civil case can take up to 22 months from the beginning of the complaint, however, it could be much quicker or last much longer, even several years, depending on the complexity of the case as well as any backlog of the courts or types of case. Due to this backlogging and lengthy legal process, it is common for settlement funding to be delayed for any number of factors. According to the same 2005 report, 56% of plaintiffs won their civil cases in state courts, and the median financial reward was $28,000. 4% of all plaintiff winners won $1 million or more. Contract cases had a higher median award of $35,000, and awards relating to the medical malpractice that went to the jury were 17 times greater than the award in tort jury trials at $400,000. Punitive damages are damages exceeding simple compensation and are often rewarded as a punishment for the defendant. 30% of plaintiffs receive punitive damages in civil trials, with the median punitive damage being $64,000. 13% of cases saw punitive damages in the realm of $1 million or more, and the average completion time for these trials was 22 months. So how often are big compensatory damages awarded in civil court? According to a 2005 report titled Punitive Damage Awards in State Courts, 9,733 cases sought 11% punitive damages and received no reward whatsoever, and 9,462 cases sought 12% punitive damages and received up to $50,000, where 2,012 cases that saw 12% punitive damages received between $50,000 and $100,000. 1,527 cases saw 15% punitive damages and received between $100,000 and $250,000, while 1,347 cases seeking 50% punitive damages received between $250,000 and $1 million. 638 cases sought 25% punitive damages and received over $1 million. The amount of punitive damages awarded differs per case type. In 2005, 6 different contract case types were reviewed: fraud, employment, unknown or other contract, buyer plaintiff, rental or lease, and seller plaintiff. 665 fraud cases sought and won 39% punitive damages, 491 employment cases sought and won 36% punitive damages, and 137 unknown or other contract cases sought and won 23% punitive damages. 1,642 buyer plaintiff cases sought and won 23% punitive damages, and 2,184 seller plaintiff cases and 342 rental or lease cases sought and won 4% punitive damages. Also in 2005, 5 types of tort cases were reviewed: medical malpractice, automobile, intentional tort, other tort, and product liability. 591 medical malpractice cases sought and won 10% of punitive damages, 6,062 automobile cases sought and won 7% in punitive damages, 101 product liability cases sought and won 4% in punitive damages, and 429 intentional tort cases sought and won 33% punitive damages. So how often do plaintiffs actually win? According to a U.S. Department of Justice report, over 60% of vehicle-related cases are won, 50% of intentional tort cases, almost 40% of premise liability and product liability cases, and almost 20% of medical malpractice cases are won. According to that same report, the most common people that individuals sued were other individuals. 11,224 individuals sued other individuals with an average award of $20,000. 7,472 individuals sued businesses with an average award of $80,000. 1,546 individuals sued the government with an average award of $80,000. And 1,383 individuals sued hospitals with an average award of $600,000. When it comes to personal injury cases, the average length of case is just over 2 years. Tort lawsuits take on average 23 months, motor vehicle accidents take on average 20 months, medical malpractice cases take on average 31 months, Premise liability cases take on average 24 months, and intentional tort cases take on average 25 months. What is pre-settlement litigation funding? Pre-settlement litigation funding are non-recourse cash advances secured against a legal settlement or award given to the plaintiff, repaid after the lawsuit is won and the settlement funded. An easier way to explain this is a cash advance against a future lawsuit settlement. Pre-settlement litigation funding is not a traditional loan. You don't have to make payments on the funding until your settlement funds, and if for some reason you don't receive compensation or win your case, you are not required to repay the funding. What does it take to get pre-settlement litigation funding? It's as easy as 1, 2, 3. The first step is with the client's permission, the lender will discuss the case details with the client's attorney. If the case qualifies for lending, an offer will be approved and presented to the client. After that, the client just has to accept the funding, and that's it. What is required for approval? In most cases, it's 2 types of individuals who are accepted. A client who is currently involved in a lawsuit and being represented by an attorney, or a client that has a lawsuit settlement and is just awaiting payment. When you apply for pre-settlement litigation funding, the application is reviewed and evaluated for approval. One part of the approval process depends on your case type. The most commonly accepted case types for funding include auto accidents, personal injury cases, medical malpractice, pedestrian injury, pharmaceutical and drug injury lawsuits, product liability cases, premise liability, wrongful death cases, and labor employment disputes. The reasons for pre-settlement funding will vary per the individual. There are plenty of reasons, though, that would require a need for funding, including cash up front to help alleviate bills and other expenses that might accrue during the lengthy legal process. There's no risk involved in the funding, and since most funding is approved based on the case type, it is extremely likely you are going to win that case. There are very few eligibility requirements for lenders, mostly just state of residence restrictions. While it does seem like pre-settlement litigation funding is a blessing, there are some drawbacks to be reviewed before applying. Firstly, you are not eligible for more than 10% of your anticipated settlement amount. The other downside is that this is a loan. Once your settlement is agreed upon, the agreed amount between you and your lender will be deducted from your settlement. In most cases, the rate percentages on the loan are larger than those of a bank loan. If you have any more questions regarding pre-settlement finance options and to find out if you qualify for legal funding, please feel free to visit lawsuitlegal.com.